My name is Michael Blakely, and I'm the founder of Entrepreneurs Collective, and I'd like to welcome you to Springboard 2021. This is a series of 15 workshops and events that we've pulled together for entrepreneurs, founders, and people interested in the space so that you can really hit the year running with updates on areas of law, marketing, recruitment that might affect your startup. Next slide, Daniel. But first, I'm going to tell you a little bit about Entrepreneurs Collective and myself. We launched Entrepreneurs Collective last year. I am a founder myself. I was previously a lawyer, but I went a little bit rogue and launched a dating app a few years back. And frankly, I made a lot of mistakes. Year one was tough. I'd never built an app before. I'd never recruited a team. I'd reviewed a lot of contracts, but there was a lot of things that went wrong. Daniel, next slide. You know, and who do you talk to when things go wrong, or if you need a referral? How do you find some good developers? Where do you fundraise? And I really struggled to find a community in London that I could call home. And certainly, you know, if you don't make the grade, you know, and being a first-time founder building a dating app, I wasn't the most popular flavor of the month. So getting into one of the top tech stars or seed camps of this world wasn't really an option for me. So being an entrepreneur, I decided to build my own. And that's what the Entrepreneurs Collective is about. It's about founders helping founders. We now have over 4,000 members, and what our mission is simple, which is to help more startups to succeed. And we do this through a number of ways, everything from organizing pitch competitions, workshops like this, helping our members to get access to credits, reviewing their decks, giving advice on fundraising. Whatever problems are facing your startup, if you come to us, we will try and help you solve them. Next slide. But today is our first workshop of the year. We have another 15 across January and February, including some great pitch competitions and some roundtables with some exceptional entrepreneurs. But this slide is today is about GDPR. Now, GDPR is obviously quite timely, given that we recently experienced Brexit, which finally came to pass. And that means that we are officially no longer part of Europe. But what does this mean for your startup? How does it change what you're doing, and how will it affect you going forward? And that's what we're going to cover today. Next slide, Dan.
Graham, if you can move.
Yeah. So today is our Pangolin data protection consultancy. It's going to be giving a presentation. This is a data security and data protection experts. And today we have speaking Graham McLeod. Move on to the next slide, Daniel. Unfortunately, our other presenter, Len Hines, who is a data security specialist and a Scotland Yard detective of 20 years, and who's worked on the UK's high-tech crime unit, unfortunately can't join us today, so Graham will be doing his section, and I will hand you over to Graham. If you have questions during the presentation, please drop them into the chat. We will try, Graham will look to answer questions at the end, but may answer some questions as he's going through if they pop up and are relevant to the point that we're passing through. Over to you, Graham, and to the rest of you. I hope you enjoy the presentation. If you have any questions or would like to connect with me, we will pop it my LinkedIn into the chat, and certainly and also a link to Entrepreneurs Collective in case you would like to find out a bit more about what it is that we do. Enjoy, guys. Over to you, Graham.
Thanks, Mike. Good afternoon, everyone. It's great to be with you. So as Mike said, we're going to just go through sort of post-Brexit data protection, some issues surrounding that, a little bit of stuff on international transfers, and sort of key considerations for you with respect to what your data protection suite of assets should look like, and steps that you need to take. So by way of background, in terms of my experience, I've been a lawyer for about 12 years, for more than 12 years now, and specializing in data protection, privacy, for at least half of my career. So I've worked with, global corporations, as well as tech startups. So like Mike said, I'm happy to answer any questions, both during this presentation and offline. And my contact information is provided at the end of the presentation. And we're sort of currently offering a complimentary advice element where, up to 15 to 20 minutes of sort of discussion on data protection. You can reach out, and I'm happy to speak with you. So look forward to that. Just by way of sort of a contextual element to data protection, there's typically a little bit of confusion or interplay between privacy and data protection. So privacy, when we talk about privacy, that relates specifically to data subjects. And data subjects are the individual person and their rights regarding their personal data. Data protection, on the other hand, is typically describing an organization's procedures and policies, their data protection infrastructure, and all of the sort of measures that go along with that. Now, today's discussion centers around the UK Data Protection Act and GDPR, which is out of the European Union. So the background to post-Brexit and what the landscape was before the UK exited the EU was that on 31st of January 2020, the UK began its what is called the transition period, which is the period in between its ultimate exit and its decision to exit. The transition period concluded on December 31, 2020. And now the UK is currently seeking from the EU an adequacy decision, which relates to whether or not the EU deems the UK to have adequate data protection, which ensures the rights of data subjects. So what is adequacy? Adequacy, like I said, is about determining whether or not a specific country has adequate data protection, which protects the rights and responsibilities of data subjects. So as you can see, GDPR restricts transfers of personal data to third countries. And now that the UK is out of the EU, it is now considered a third country, as it's no longer in the European Economic Zone. So the European Commission has the power to determine whether or not the UK will ultimately be adequate in terms of data protection, and that's expected sometime in 2021. And a positive adequacy decision means that the UK will not have to implement any additional safeguards when transferring personal data between the UK and countries that are in the EU or the EEA. So as I just said, if without a positive adequacy decision, transfers of personal data from the UK to European countries will constitute a restricted transfer, and that will mean that there are additional safeguards and mechanisms that need to be put in place. Now, what we're looking at in terms of practical steps for compliance, this all relates to the application GDPR and all of these elements here. We're going to look at some of these as, at sort of a top level, but again, given that as an early stage startup, your sort of immediate repository of personal data will include two elements. One is the personal data relating to your employees, and two, client personal data. So your cornerstone data protection documents are going to be privacy policy, cookies policy, and internal data protection policies and procedures. So we'll review those a little bit later on. And depending on the commercial dynamics of your startup, will drive whether or not the issue of international data transfers is sort of a going concern for you. So in terms of the assets that a startup needs on the data protection front, at its baseline, and you can see down at the very start of laying the foundation, a startup needs to register with the Information Commissioner's Office. And that's sort of the beachhead with respect to establishing data protection protocols and demonstrating compliance. The next level is a privacy policy, which is a client-facing external document which delineates how you collect, use, and process personal data and your reasons for doing so. It also outlines data subject rights, which is critical so that the people whose data you're processing know exactly the rights that they have with respect to that data. And in tandem with the privacy policy is the cookies policy, which, as you know, drives the collection of metadata and elements of that on your website. So the next level after your external facing privacy policy is developing a data protection policy, which is internal. And the rest of these documents, which are stacked to form your foundation and cornerstone data protection infrastructure, are all internal. So your data protection policy deals with how to handle, store, delete the responsibilities of your employees and everything that relates to that. And in tandem with that is a data retention policy, which drives how long you store the data for, how it's destroyed, confirmation of deletion, and elements that surround that. Another critical element, which is sometimes overlooked, is the data breach policy, which deals with the spectrum of data breaches that at the sort of more benign end could be a misdirected email which contains personal data and is sent to the wrong party, how to deal with that, and at the more sort of significant and high impact end, where you're looking at things like ransomware, hacking and events like that. So a data breach policy is absolutely critical for crisis management situations and how to deal with public relations elements. And then on an annual basis, the minimum, a data protection impact assessment should be conducted with respect to your business. So by that I mean it's essentially an internal audit which looks at how all of these elements of your foundation are functioning, and also determines whether or not the controls that you put in place to ensure that processes are running properly are also effective. Now, there's a whole other element on top of the foundation, which is the sort of additional assets. But these are not exhaustive, and the ones listed here, there's at least another 5 to 10 on top of that, such as password encryption, classification policies, and various other types of policies and procedures. However, with startups, these additional assets typically only become necessary if you're working in the medical or tech space, where approval from a large corporate entity or a public entity, such as the NHS, is necessary. And these types of data protection assets are typically also required if you're pursuing a VC round and possess sensitive personal data. So application of GDPR to the current situation post-Brexit is that GDPR continues to be retained, and the elements of GDPR and the requirements are retained in UK law. And the framework now essentially is being labeled the UK GDPR. So the UK GDPR sits alongside an amended version of the Data Protection Act, and the key principles remain unchanged. You can see that the application of UK GDPR applies to data controllers and data processors, and that's something that I'm happy to explain further. It drives the commercial dynamic between sending and receiving, and who dictates how personal data is handled. But for the time being, UK GDPR applies to data processors who are based outside of the UK if their if their activities relate to offering goods and services to individuals in the UK or monitoring the behavior of individuals taking place in the UK. Now, in terms of international data transfers, like I said, this may not be applicable to your startup because you are operating solely on a domestic level. However, so it doesn't apply to you if personal data is never transferred to a, from the UK to a country, territory, or sector that is outside of the UK. And you can see if that applies to you. What it actually applies to is if your business is UK based, is subject to the UK GDPR, which it would be, and you are transferring personal data to or from, or receiving personal data from other countries, including European countries. So under the European GDPR, which is the original GDPR, a European-based data controller or data processor can transfer personal data to the UK where these three elements apply. So as we talked about before, an adequacy decision, meaning that like the country has in the EC's eyes an adequate level of data protection, appropriate safeguards, which in this case for a tech startup would be the standard contractual clauses. And those are a set of standard contract terms which are appended to agreements where personal data is being transferred. And they really delineate the specific responsibilities, obligations, and liabilities of the data controller and the data processor. And I'm happy to discuss that further as well. It's standardized language, but it is detailed and requires both parties to really give input to it. The third way or methodology whereby personal data can be transferred under a restricted transfer dynamic is where an exception applies. And you can see the exceptions are there. I'm not going to list them, and obviously this presentation will be made available to everyone once concluded, and it'll be distributed. So essentially, if you are transferring data internationally, these are the three elements that can underpin your ability to do so. Now, going back to the foundational diagram of what's created, and that the first step was to register with the Information Commissioner's Office. The ICO requires the data protection officer be appointed for your business. And the critical language in terms of who that person can be and the qualifications that they possess are that they are independent, an expert in data protection, adequately resourced, and report to the highest management level. So for more information on the requirements of a DPO, the ICO website is absolutely tremendous. I was doing some research on there a few days ago, and one of the links was down. I emailed them. It was back up within half a day. So I highly recommend reviewing and sort of delving into the ICO website, as it's a tremendous resource. And the other, going back to the whole dynamic of whether or not an international transfer would apply to you in the context of a tech startup, it would also arise if you are using third-party software provided by a European company, or if your company has a website hosted by a European country. And so that's another consideration to make. And on the issue of representatives, and as a jump off point from that, if you are transferring personal data into Europe or receiving it from Europe, you do need to have a local European representative, and that's what we're going to discuss now. So if you are a UK located data controller, data processor, which you all are, and you have no offices, branches, or other establishments in the European Economic Area, and you offer goods or services or monitor the behavior of individuals in the EEA, then you do need a European-based representative. And this is something that we can help with as well. So again, happy to discuss questions about that and to provide guidance offline. So as you can see, without a base of operations in the European Economic Area, the EU GDPR requires the appointment of a representative in the EEA who is actually located in the EU or EEA state where the individual's personal data that you're processing are located. So if you are processing data of individuals who are, let's say, located in Poland, you would need to have a local representative in Poland to comply with the EU GDPR requirements. And that person can be an organization established in that jurisdiction who can serve as a representative, as well as sort of deal with any questions or queries or anything related to the supervisory authority in that area. And typically, the representatives are law firms, consultancy companies, and organizations like that. So to prepare for whether or not you need a representative, you need to consider, as I said, which state the personal data is being processed from. With respect to engaging a representative, you obviously would want to have a written mandate with them, a service contract, which is very comprehensive and fair and reasonable, and obviously protects your interests, and enable them and empower them to be able to deal with the supervisory authority on your behalf. This information would also need to be included in your privacy notice. So this sort of takes us to what will be discussed at the sort of tail end of the presentation, which are key considerations for you on a go-forward basis in terms of updating your documentation. And as with all privacy notices and external facing client-related documentation, that information needs to be published on your website so that it's easily accessible to the data subjects for whom you're processing personal data. Now, again, this may not apply to many of you, if any, but these are the exceptions in terms of not having to appoint a European representative. And that's where the data controller or data processor in the UK is a public authority, or as you can see, processing on an occasional basis. It's low risk, and it doesn't involve large-scale use of special category personal data, and special category personal data is obviously more sensitive. The second requirement, or sorry, the second of those two is conjunctive. So it means that all three of those elements need to be met. And again, it's sort of a higher threshold to reach. So it would require, I think, some sort of detailed analysis and some legal advice and insight. Now, the penalties for not having, the local EEA representative in the state that applies to your personal data processing can range from administrative fines, as they would in the same manner as a data controller and data processor would be exposed to those if they were the ones actually operating in that EEA state. So, as I'm sure some of you know or have seen or heard about, the EC is fairly draconian and fairly prosecutorial in its application of administrative fines. So, it's critical to consider whether or not, this applies to you. And part of that, as a first step, when you're establishing, your relationship with the ICO and registering, is to ensure that you do a thorough mapping of your data flows in terms of the points of entrance and exit, the software platforms that you're using, and the service providers that you're also engaging. All three of those will help inform whether or not you are, crossing borders, or whether there are, elements of your data protection that need to be covered off by this. So this is the data security elements, which admittedly, this is Len's sort of purview of expertise. So I won't be able to answer questions specific to this, but I know Len would be happy to offline, and the same offer to sort of have a discussion on a complimentary basis is there. So the ISO standards still remain relevant in the post-Brexit world of data protection. Just as I recommend going to look at the ICO's website, it's also worth investigating ISO standards and to see, what those requirements are. Supply chain changes are inevitable. So, you want to look at where your third parties are based, and that goes back to what I was saying about, if there's a company hosting your website in Europe, if you're engaging third-party processors for personal data, you need to determine the jurisdiction in which they're located because of not only the data protection requirements, but you want to ensure that their data security requirements are at the same level, if not better than your own. And that feeds into the agreements that you have with these third-party processors, or with third-party providers, to ensure that their levels are hardwired into any contracts or agreements that you have with them, and that all of that is specified to a very high degree. So, as I said, Len will be able to speak in more detail about this if you have any questions specifically related to that. And I'm sure that we can sort of compile a list of questions or comments and forward them on to him. So key updates for your startups to consider. And this is sort of a summary of what we've talked about prior. So you need to identify the personal data which was processed before the transition period. Before the post-Brexit, and that's called legacy personal data. And so data before then can still be processed with respect to adequacy. And it's only after 1st of January 2021 that the new UK GDPR applies and that adequacy no longer applies. So as part of that process, you need to look at your privacy notices and cookie policies. As I said, you should be doing this on an annual basis regardless. And a great way to do that is to undertake a data protection impact assessment, which is known as a DPIA, to ensure that these policies and privacy notices and everything that relates to those is up to date and current and in line with the amended legislation. So, given that you all have registered with the ICO already, I imagine, or at least you intend to do so, the data protection officer must be accessible, easily accessible from the UK. That's a requirement as well. It can't be someone sort of off in a shanty somewhere that no one can get a hold of, because DPOs typically deal with some of the most critical issues and can provide real time solutions to data protection issues that arise. And if you are undertaking or subject to restricted international transfers, you need to have the DPO or your representative in the other jurisdiction also easily accessible, so that there's a free flow of information and communication. This is a pretty dense slide, so I won't go through it in great detail, but the things that you should really sort of drill down on, like I said before, your privacy notices, which include your cookies policies, integrating and considering the elements and changes to international transfers. You want to review your lawful bases for processing, which are the reasons why you process personal data. Typically, the most sound ones are that you're processing for legitimate business interests or under contractual terms. Consent is usually, not to be indelicate, but the worst basis for processing, because consent can be withdrawn at any time. So you're sort of subject to the whims and idiosyncrasies of data subjects. So, like I said, the two critical ones are typically legitimate interests and contractual basis. And in jumping off of the data subject rights, the UK GDPR applies to all processing of personal data, regardless of the location of individuals for whom the personal data is processed. So typically, what I would say is that if you've already been compliant with EU GDPR, it won't require much tweaking. And GDPR, I've always advised my clients that GDPR has been the gold standard. So if you use that as sort of your baseline, and integrate the changes and sort of supplemental requirements from the UK, like you're in good shape. And that leads to the documentation in terms of, again, integrating the changes regarding these restricted international transfers, and updating your lawful bases as well. I can't impress upon you the need to do a DPIA as soon as possible, not only from a data flow mapping perspective, but also to look at the ways that potentially you could be exposed to risk. A DPIA can also help with exposing other business risks that you may not have been aware of. So that should be conducted on at least an annual basis, if not more frequently. And as I said, with respect to the data protection officers, they need to be easily accessible from all establishments, whether it's domestic or in the EEA. So that essentially is it for me in terms of the overview and the presentation. And I'm happy to take any questions or discuss any comments.
Yeah. Okay. Great stuff. Thanks, Graham. Much appreciated. Keeping us up to date there with all the changes. We've had some questions come in, so I'm going to pick a few out for you. From Melanie, she has a question. I've recently created a website for my IT training and consultancy business. I have a form on my website where people can request information. Do I require data protection policy and data retention policy on my website?
The short answer is no, because your data protection policy and your data retention policy are internal documents which you retain and don't share with clients. Your client-facing documents are your privacy notice or privacy policy and your cookies policy. The internal documents are, one, to be able to have these policies and procedures as part of your processes and operations, and two, to be able to show that you are compliant to any supervisory authority if the case ever arose that you were, inspecting.
Yeah, perfect, Graham. So I guess, yeah, so it's mostly the policies you have are the ones that you mentioned earlier, the privacy policy and yeah.
And cookies, yeah.
Yeah.
Never forget cookies.
Yeah. Okay, and who do we have next? Question for you. How is data transfer interpreted in the case of a startup using offshore developers for development and maintenance when the data is hosted in UK-based data centers and servers? So, Kevin, I'm presuming when you say offshore that you're meaning, I guess, outside of Europe as well. But drop it into the chat if you mean, I guess, Europe.
Yeah, it does.
It does. Perfect.
Okay, so if you're having personal data sent offshore, whoever is working on that personal data not only needs to comply with the UK GDPR, the requirements of UK data protection, also their domestic data protection legislation and regulations. So if you were using someone in like a truly offshore jurisdiction, such as like the Cayman Islands, they have to comply with not only their own legislation, but also the legislation and regulations in the UK. And if that personal data relates to European citizens, they need to comply with the data protection legislation and regulation of the jurisdictions in which those data subjects are citizens or residents. So that it creates a sort of a more complex dynamic, but elements like that should really be built into data transfer agreements so that it's very clear under which regulations, rules, and legislation you're operating and the standards to which every party is being held.
Yeah, so I came across, so we actually used offshore providers ourselves, Kevin, on my own startup. So having been through this process, we looked at this and essentially, the fact that they can access the data outside of Europe means that essentially they could, if they wanted to, cut and paste or access it in their own country. And that means you're taking the data from a safe place like Europe or the UK and allowing access in an unsafe place like India, where regulation is a lot more limited. But like Graham was talking about, if you can, it's not that you can't do this, but what we did in our end was basically we did a due diligence questionnaire on the third-party provider, got them to explain what security you have in place, who will have access, and then put model clauses, which I think Graham mentioned in his earlier in the presentation in with them. And certainly, I think that's something that Graham can help with if you guys need to go through that process.
Absolutely.
Okay. Right. Does the size of it, from Paul Irving, does the size of a company determine any aspect of this? If the size of the company does, how and why?
So if the company is large and it has multiple locations and multiple establishments, that will change the dynamic of your personal data transferring and your policies and procedures. In terms of if it's a centralized location, if there's only one physical location or one virtual location, the policy and procedures are all encompassing to that jurisdiction. However, like I said, if you have a large company and you're speaking in terms of a large company that has, like I said, multiple offices in multiple jurisdictions, that will definitely affect in a significant way.
So Graham, I'm sorry. I guess probably from a startup perspective, what I suspect he's talking about is, you know, if obviously some of these big corporates are expected to put all these policies and procedures in place, you know, but from some of the startups like myself, maybe we have like less than 10 employees. You know, is that taken into account? Does that let us off the hook? What does it mean for us?
Well, it definitely doesn't let you off the hook. I mean, you'll be held to the same standard, or at least have to comply with the big corporate partner with whom you're working. But, you know, there is sort of a typical sort of scaling element to this, whereby, you know, the more people that you're dealing with, the more complex your data protection infrastructure becomes.
Yeah, okay, great. Okay, another question. Does the location where data is hosted affect compliance? So I'm trying to think. Maybe Nigel, maybe if we could get Nigel, unmute Nigel, so you can, I'm just trying to understand the question a little bit better.
So essentially, I just mean, let's say if the servers in America, for example, and the startup is located in England, does the location of the servers actually affect compliance with the GDPR?
Okay. Mike, you want me to, I'm happy to take this one too. Yeah, so it does, because obviously the US being a foreign jurisdiction, considered an overseas jurisdiction, and the US not having, you know, even remotely as close to a robust and comprehensive data protection infrastructure as Europe or the UK, it does impact it for sure. And also not only where the servers are located, but also who the data subjects are. So if it's, you know, if it's servers in the US which are processing the storing or you know, holding personal data on European citizens, then again, you're entering into another sort of more complex dynamic, where not only will UK data protection laws and the UK GDPR apply, but also EU GDPR. The US has, you know, the US Privacy Shield, and different states have their own different levels of data protection regimes. So in short, Nigel, where the servers are located is a critical consideration for what data protection laws and regulations need to comply with.
Okay, great stuff. And then we had another question from Andrea, which I missed earlier on. Does this all apply also if you serve business customers?
I think we need a little bit more detail on that.
Yeah, so maybe if you can unmute Andrea if she's still here. I know she was having a few connection problems. Or Andrea, sorry. Okay. Can we unmute Andrea?
Hello.
Andrea.
Hi. Thank you. Thanks for the very interesting webinar, and thanks for your time, guys. So the question is, so our startup is basically looking to work with food producers across Europe. And obviously these are business customers. They're not going to be, we're not going to touch retail clients at this point. So my question is whether based on, because in your presentation and in your slides, you specifically make reference to personal data of people rather than, you know, anything related to businesses. And I was wondering how would that apply in our case? I don't know if you need further clarification still. I'll be happy to give them to you, or if this is enough. Thank you.
That's certainly sufficient. In essentially all commercial dynamics, there will be exchange of personal data, both internally in terms of your own employees, and anytime that, I mean, personal data is such a huge umbrella now. You know, a name on an email constitutes personal data. So while you may not be processing personal data at the retail end downstream, you still need to have policies and procedures which relate to the processing of personal data with the entities that you're dealing with.
Exactly. And of course, you also have your employees as well. So you'll be you'll need policies, the internal ones for those guys. Looking to the near future and the direction of travel that the EU is heading. This is from Sam Jones. The Digital Services Act that was announced in November. What do you think of? Do you think future legislation will be addressing, focused on this year? Okay.
I mean, in terms of predicting legislative palettes or, you know, legislative direction, it's always challenging. I think that what we're looking at generally across the board from a global perspective is that there is a tightening of regulation, and there is also a heightening of regulatory oversight. So regardless of the jurisdiction, I think you're going to see that in a lot more of the amendments to different data protection acts and regulations. You know, in the climate now, you know, I've read extensively that data is now, personal data particularly, is going to be more valuable than oil. So just as, you know, that industry is highly regulated, so too will data protection continue to be more regulated, and we'll see, I think, some pretty interesting developments with respect to legislation developing over the next 5 to 10 years.
Okay, perfect. Let me have a look what other questions we have left. Right. Gillian Wilson, can we unmute Gillian? She's got a question.
Hi guys, thanks for the fabulous presentation. I have sweaty palms and a racing heartbeat right now. My question is, we did a DPI at the end of last year, but we have extensive footfall to our website, so 98 countries worldwide. And I'm just wondering if you have, we've already reached out to a few data protection organizations, but do you have like regional hubs in terms of being able to manage all of the elements which you've spoken about in today's presentation, in terms of safe transfer of that data and kind of management and governance of that data?
Mike, do you want to field that one?
Yeah, so just to clarify, so what you, in terms of regional hubs, what you mean, sort of front-facing policies to manage the data coming into you guys?
Yeah, no, so essentially where I think Graham was speaking about a local regional representative.
Yeah.
So I can't imagine, well, I don't want to be wrong, but I can't imagine that you need to have 98 separate regional representatives, but I don't know, obviously.
Yeah, so it's an interesting one, and obviously a lot of huge companies you know, struggle with this, and you know, because obviously you can potentially go to each country that you're active in. You can look at the data protection laws in that place, and some will require DPOs if you are if you know, processing data, which, you know, potentially you could be. It depends obviously on the flow of the website and what data is being exchanged, and whether they consider the fact that they're presumably their customers or filling out their forms.
Yeah.
Pardon?
Yeah, no, they are. So they subscribe, and quite a few are customers. So
Yeah.
And there's such diversity in terms of regions. That's why I'm kind of not panicking, but you can imagine.
Yeah, so it depends on the definition, because if they are subscribing to you, then you're potentially not processing the data. The data is being accessed, but they don't have access to data, right? They only have their own data that they're putting in.
Yeah. But the servers are located in Israel and America, so we're UK based, but
right. Okay. So then obviously you definitely, with the UK and Israel, then you definitely want to take a look at both of those jurisdictions.
Yeah.
At what the requirements are there, and then also maybe you'd want to do a little bit of due diligence. Have a look at, are you using it? Where are your do any of your other third party service providers, I don't know if you're using someone to fill the orders or what are the key components in your business, but you probably want to look at the key hubs and databases that you have, maybe map them out in an information flow, and then check those sort of major countries where you've got data. Quite often, you can use the same data protection officer. Sometimes they require local data protection officers, but most of the time they just require a name. And for you to register. So certainly it's something that that you probably need to look at.
Yeah, that's fine. We just didn't get that feedback from the organization which we'd kind of worked with at the end of last year, and it's just through this presentation, as you've gone through the granularity, I'm starting to see red flags.
Well,
so,
I believe that Graham has given a free 15-20 minute consultation. So maybe, this is a good one for you to take up with him.
Definitely. And Gillian, there's far more information that could be sort of disseminated in this presentation with respect to even a higher, or sorry, I guess, depending on what you want to look at, a deeper level of granularity. So I'm happy to have a discussion about it. I think there's going to be a unique interplay with adequacy, restricted transfers, and local representatives. So it's obviously it's a moving target right now, but I think there are definitely things that can be sort of focused upon and develop a solution for.
Yeah.
Okay, perfect. Thank you so much. It's been really useful. Thanks.
You're welcome.
Another interesting one for you here. So this one from Margaret Ashley, who is a sole trader and a voice actor who sells her voice, not a physical product. Correspondence is via email and sending MP3s to a client. Small business. What do I really need to put on my website? I have a privacy policy on there already. And do I have to register with the ICO?
So we'll deal with the second question first, which is yes, you need to register with the ICO, just to ensure compliance. You never want to be caught offside. If, again, given the climate and how things are shifting into a more prosecutorial mandate for regulatory authorities and supervisory authorities, you always want to err on the side of caution and make sure that all the boxes are checked, so that, if they are doing a random sampling of audits or inspections, you can point to this, repository of documentation and also the steps that you've taken to be compliant. With respect to your privacy policy being published, that's a great first step. If you're using cookies on your website, you definitely need a cookie policy. And at a baseline, I would highly, it's critical to have the internal data protection policy. If you're not going to, or you don't have the resources or sort of ability to scale up in terms of like the data retention policy, the data data incident response plan, and that type of thing, you need to have at least the baseline of a data protection policy which touches on those points. So again, it's a discussion that I'm happy to have offline if you need any further advice.
Yeah. And certainly, and I guess just to put it into sort of context as well, from a startup perspective, the registering with the ICO, whilst it might sound, cumbersome, is quite a quick process, and it's £35 a year. And a big part of it is presumably people are contacting you for work. So even though it's only yourself, then you are, according to the ICO, processing other people's data, which is why they want you to register. But you can set up a direct debit, and that could just come straight out, £35 each year to fill those obligations. So yeah, and certainly in terms of the other policies, then certainly there are templates out there that you can get if you need to tick those boxes. But
yeah, and just as sort of an ancillary point to the ICO is that you can also sort of point to that to clients to say that you're compliant. I mean, it sort of adds another level of professionalism to your business. And it's almost like having a stamp of approval.
Yeah. So certainly, I guess maybe and certainly in terms of smaller businesses, if you're looking as a startup to partner with a corporate or maybe join a pilot scheme or be involved in sometimes in relation to raising VC funds, then actually one of the quick things when I was a lawyer, I worked in compliance, and we used to acquire startups. And one of the quick rules of thumb was to just frankly go on their website and check out their privacy policy and T's and C's, because you can sort of get a feeling if the privacy policy is 5 years out of date, then you can sort of quite quickly realize that actually these guys won't be, if their privacy policy isn't up to date, then it's unlikely that their internal documents are going to be. But I think, at a minimum, if you're working with other businesses, then, keeping the front facing documents like the privacy policy and the cookie policy up to date is key to make you seem professional. Okay, so I think that we're at the end there in terms of the questions. If I've missed anyone out, please feel free to contact Graham here. We will be following up with all of you guys and sharing the video of the presentation. So if there's anything that you've missed in the materials, obviously Graham is on hand to answer any questions if you want to reach out. From my perspective, I think we posted earlier on in the link a link to our Springboard platform at the Entrepreneurs Collective. But for any of you guys that are interested in finding out more, please do register on there, and feel free to get in contact with the team. And thank you, thanks to you all guys for your